Welcome to Court TV on Crestview Community TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching Docket Day. Now, Docket Day, last year and in previous years, it was the biggest court date. Now we've added a court date with pretrial conference happening the week before Docket Day, so Docket Day has shrunk down and gotten somewhat smaller. However, you're still going to see defendants who maybe have been in court for the first time. Maybe their appearance was waived at pretrial conference, which we spoke about in that video. But when someone's called to the podium, you're going to see, again, one of a few things can happen. They can enter a plea. At that point, the case would be over, and they'll get sentenced either today, live on Crestview Community TV, or they'll get sentenced in a sentencing hearing down the road on one of those miscellaneous dates that we'll talk about in another video. They could also ask to continue the case. At that point, it would get set to another cycle 6 weeks down the road. The last thing they could do is they could announce ready for trial. And that means, hey, we're ready, when we're going to send this case to a court date called jury review. And then from that point, the case will get sent to a jury trial. And I know that's what we all really, really love to see. Those obviously are rare. They don't happen a lot. But we all get excited when we hear that, ready for trial.
Good morning, Your Honor. Your Honor, I have two cases on today's docket. The first one I'm going to call is Mark David Curtis. Your Honor, I've got a written plea on that. May I approach?
You can early term when it's statutory.
All of the terms are below the second box, Judge.
I just want to make sure. I just want to check one thing. Mainly the state signed it. Okay, thank you very much.
Judge, did I sign it? Now that I say it. No,
That's all.
yes. Your Honor, the next case I have is Travis Abity. That's case number 22CF2459. Your Honor, the state related an offer Friday evening. I was unable to catch up with my client this weekend. I anticipate that will be able to resolve the case. Rather than taking this all the way to a pretrial conference, I checked with the clerk. She advised me you have a miscellaneous day on 3/14. If I could leave it set for that for a plea.
Only set for
Which day, Judge?
Thursday.
That's fine, Judge. I just didn't know that was an option. I didn't want to clog up your, I didn't know what you had happening.
That's the 22nd. Yeah, that's fine. I'll be here.
What date was that, Madam Clerk? 22nd. All right, Judge, I'll see you then. That's fine, I'll see you then. Thank you, Your Honor.
Thank you. Have a nice day.
Yes.
Ms. Reed.
Hi, good morning, Judge. I have one case on the court's docket this morning. Okay.
Is that your name?
Yes, it is. Jonathan Richard Goodhart. Oh, you don't? It is 23 CF 2209. Your Honor, we just put it on today for plea or continue for PTI status. I've got the signed written plea agreement. I'm just waiting on the PTI referral as well as the PTI agreement to be signed. So I would just ask if we could get it on a miscellaneous court date so that the paperwork could be finished.
March 14th.
Okay.
If he did, and just come off with it.
We have to enter a plea agreement, Your Honor, so I will be here to.
Just a written agreement. Okay.
That's okay. Great. All right, that's all I
That'll be
have.
in the morning without subpoena.
In the morning without subpoenas, March 19th.
Thank you.
Got it. May I be excused? Thank you.
Mrs. Merrifield. Morning. You want to do yours first or Ms. Flair?
I'll take the cases under Mr. Flaherty, if that's okay, Judge. Good morning, Your Honor. Brady Merrifield on behalf of Alan Brooks, and that's 23 CF 1462. And Judge, we've reached an agreement, if I may approach.
The defense is okay with the score sheet?
Yes, Your Honor.
Will you announce the plea?
Yes, sir. In 23 CF 1462, Mr. Brooks is withdrawing his previously entered not guilty. He is entering a no contest plea. Count 1 is 36 months probation, $40 per month cost of supervision, $967 in court costs, substance abuse evaluation within 30 days, and any recommended treatment within 60. He's to continue his current mental health treatment and provide proof to probation, and continue to take all prescribed medications. He'll attend an anger management course, have no contact with Sarah Bistocki, no direct contact with Alyssa Castro or Bryce Williamson. He'll abide by the terms of the injunction, possess no firearms, and maintain gainful employment, or show 2 applications per week, or provide medical documentation to show the inability to do so. He agrees to extend the current risk protection order for 12 months, and count 2 to false imprisonment would be dismissed. It is a withholding adjudication, Judge.
That states agreement, Your Honor.
Marcy?
Yes, Your Honor, the state has complied with Marcy's law and the victim did agree that this was a proper sentence.
Those in, please raise your right hands. You swear or affirm the information you about to provide this court is the truth and you are true to help you. So you heard your terms of the plea agreement. I see those terms are contained in the written plea agreement. Jesse, sign it, please sign. So if you read this closely, gone over it with your attorney, make sure you had understood all the legal ins and outs of this. So,
Yes, Your Honor.
the one thing I would point out, just by way of clarification, is that there's a lot of requirements in this probation. Do you agree?
Yes, Your Honor.
Okay. And not only is there, evaluations that are required, of course, court costs, I'm not worried about that as much, but you got an anger management course.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Okay, Mr. Brooks, as I was saying, there are a number of conditions of this 3 years of probation. And I just want to make sure that, one, you're aware of them, and two, that you kind of understand these are serious conditions. importantly, there's no contact. You're going to be going through a divorce, right? Right?
Yes,
That's
sir.
what I just understood. Okay. You're gonna have to go through your attorney's office. You can't pick up the phone and negotiate with her. You can't have any contact whatsoever, even if she calls you or texts you. You understand? It's a one-way, no contact. You understand that?
It's easy, Your Honor, yes, sir.
Okay. And it's in addition, you've got an injunction. That's one thing. And then you've got this condition of probation. That's another thing. So even if the injunction goes away, this 3-year probation, you have no contact as a condition of it. Do you understand that?
Yes, I
The
do.
reason why I'm pointing this out is law enforcement gets real antsy when they deal with this. And the reason for it is, honestly, we've lost law enforcement over this issue. Okay. So they take it real seriously. You need to take it seriously. Do you understand that?
Yes, sir. Your Honor.
And there is obviously the same kind of situation as with the firearms. As a condition of the probation, no firearms. In addition to that, there's an RPO that's going to be extended for 12 months. Those are two separate things, but it equates the same thing, no firearms. You understand that?
Yes, I do.
Okay. Very good. Based upon that, you understand this will be a final resolution of this case. This is obviously waiting some valuable legal advice. Yes, sir.
Just a clarification on the no contact and the no direct contact.
Sure.
Specifically, what would be the difference between the no contact and no direct contact between the different individuals?
There is a strict prohibition of contact with the first listed person. The other two people are neighbors in the community, so no direct contact. That's why we articulated it that way.
That's a very trafficking. I appreciate you asking that. Not clear. And I think what you're saying, the no contact provision, essentially, not essentially, it requires that you not have, you can't be within 500 feet. So, am I reading this, the no direct contact? You're right, there's absolutely no definition of direct versus other contact.
That is with people.
Why don't you explain it?
The no direct contact,
What does that mean?
there is no prohibition that he be at any sort of 500 feet away from them. They are neighbors, so the no direct contact essentially would be similar to peaceful contact, like a child that can return to school. If he sees them outside, he goes back inside his house. He does not have any sort of contact or communication whatsoever with those persons.
It's not a defined term. That's really tricky, by way of. Because the thing is, and I'll say this, Mr. Brooks, the purpose of my questions is twofold. One is that you understand what you're agreeing to, and that it's done freely and voluntarily. That's the purpose of my conversation. But if it's not clear what the terms say, you can't be clear about it, because I'm not clear about it. Who's convicted?
You're an victim of service documents. Sure, witnesses. Your Honor.
Right. No direct contact, no contact. Okay, so the state and the defense is in agreement that the no direct contact will allow you to be within 500 feet. It's just
Yes, Your Honor.
you can't have any verbal or obviously physical contact. You can't go, couldn't approach them or whatever.
Exactly, Judge. And that was certainly our intention.
This is on the record, you know. It's tricky. I mean, so you need to make this clear. Because if law enforcement is going to interpret this, which is what they have to do, It's a very good question. I appreciate you asking. Why don't you just put a star on this and say, the 500 feet requirement would not apply.
Thank you, Judge.
Something to that. Put a little asterisk when the direct, say direct contact.
May I approach, Judge?
May. So, Mr. Brooks, just want to make sure you understand the difference between no contact and no direct contact. So, no contact is kind of our standard. You can't go within 500 feet. You can't approach their car. You can't go where their home is, anything like that. No direct contact because the people are the folks you can't have direct contact with are next door neighbors. You would be within the 500 feet. So this just means that you can't go approach them, talk to them, etc. Do you understand all that?
Yes, sir.
So based upon this testimony, the court will accept this plea agreement. Court, as to count one, will withhold, there'll be withhold adjudication. The defendant will be sentenced to 36 months probation with the fees and costs. Obviously, the conditions of the probation are significant, and I'm going to read off some of them, but these are all that are contained in the agreement. But then a substance abuse evaluation within 30 days, recommended treatment within 60, continue current mental health treatment, and continue with prescribed medications, attend anger management course. And then you've got no contact with Kostaki, no direct contact with Castro or Williamson. And then separately, you abide by the terms of the injunction, possess no firearms, maintain gainful employment, and the RPO related to the weapons would also be extended for 12 months. Any questions?
No, sir.
Thank you.
Thank you, Ryan. Judge, the next case I have is Miranda Cardwell in 23 CF 1171. Where the state has an announcement, Ms. Cardwell?
Yes, Your Honor, this time the state's been in no cross, Ms. Cardwell.
Very good. Court will announce no cross.
The next case is Matthew Coffey, Judge, in 23 CF 2480. He is an inmate. Judge, we've reached an agreement, if I may approach.
You may. Thank you.
This one she's behind me.
Very good. Defense an agreement on this issue.
Yes, Your Honor.
Would you please announce?
In 23 CF 2480, Mr. Coffey is withdrawing his previously entered not guilty. He's entering a no contest plea as charged. Terms are 60 months of probation, $40 per month cost of supervision, $967 in court costs, a 10-inch proof of batterer's intervention program, a substance abuse evaluation within 30 days and begin any recommended treatment within 60 days, a psychological evaluation within 30 days, begin any recommended treatment within 60 days, no contact with KK unless KK requests contact in writing, adjudication to be withheld.
Your Honor, that is the state's agreement, and the state has complied with Marshall's law.
And is KK
Yes, Your Honor.
Point of clarification, when you say show proof of batterer's intervention, is that something that's already taken, is that program?
He is not, Judge. It's just attend and show proof upon completion of batterer's intervention.
because this is a 5-year probation, we want to put some time limit, and when, in theory, you could wait 4 years before he even was evaluated for a batter's intervention.
Considering the other requirements that he has to do within the first 30 days, we did not have a time frame on the batter's intervention while he is released.
I'm not saying it has to be within 30 days, I'm just suggesting that because of the lengthy probation and total lack of any timeline, it would not be outside the realm of this agreement, nor the legitimate possibility that he waits 4 years. Is that what you all want to do? I don't think that was your intention, but I'm not asking you to do it within 30 days. How about 6 months?
Yeah, I think that's appropriate. Yeah, if the court would allow 120 days.
Why don't you go ahead and put that? Mr. Coffey, would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? I do. Okay. So with this one minor change, you've heard your attorney state the terms of your plea agreement, and she's, go ahead. Thank you. And I see that, check, make sure, you signed it. Have you read the plea agreement closely? I have. Have you gone over it with your attorney, make sure you understand all the ins and outs legally of this? I have. You understand by entering this plea agreement, you're waiving the right to go to a trial, waiving some other valuable legal rights in order to get a final resolution of this matter? Yes, sir. You believe this is in your best interest? Yes. Very good. Based upon that testimony, the court will accept the plea agreement. There'll be a withhold adjudication. She went back. It can't be completed. It's a 6-month program. If it has to be completed in 6 months, he has to do it immediately. Once you say it has to be initiated within 6 months. Initiated within 6 months, not completed. It's important we're real clear, so we're clear about what your requirements are. So that the last thing we want is you to enter into this thing and there be an inadvertent violation. I'm not trying to trick somebody. We actually want you to be successful with this, get through it. So, again, accepting the plea agreement, there'll be withhold adjudication, and the defendant will be sentenced to 60 months probation with the fees and costs that are contained. You must attend and show proof of the batter's intervention program. Got to initiate it within 6 months. There'll be a substance use evaluation within 30 days, and begin recommended treatment within 60. Psychological evaluation within 30 days, and beginning recommended treatment in 60 days. And importantly, no contact with the victim, KK, unless KK requests contact in writing. And no contact is one-sided. Even if KK contacts you, you can't have contact. So let me just ask you this, kind of for his benefit. How would it procedurally happen? If KK puts it in writing to whom?
To probation.
Probation?
It would be to probation, and then there would be a modification during the normal process of that.
Okay. So, you understand that would require an actual change in the probation order. Okay. Oh, so if she just wrote you a letter and said, I want to have contact. Oh, well, you wrote me, and that's not enough. That's what, again, trying not to get you in a situation where you do something inadvertently and you get violated. This is a lengthy probationary period. You're gonna have to really get on your P's and Q's in order to maintain go out requirements. Okay, you can do it, but it's gonna require some work. Okay, any questions?
Yes, Your Honor.
Very good.
And Your Honor, this is a negotiated downward departure based on a legitimate or unenforced plea bargain.
Very good. And Marcy's law?
Yes, we have to find Marcy's.
And Judge, the defense would request that he check in with probation by 8 a.m. tomorrow morning, because we're uncertain how long it's going to take for his release to go through today.
If you can get over it, basically as soon as you get out, if you can get over there today, you need to get over there today. If not, obviously if you get out at 4 o'clock, you can't get over there. But if you can today, try and get it today. If not, first thing in the morning, 8 o'clock.
Thank you.
Okay, thank you.
Judge, the next case I have is Troy Graves, 23 CF 2428. There's a waiver on file. We set Mr. Graves to clear continue. We are still working out some details. Mr. Graves lives in an adult facility out of state, so we're having to confirm some of those requirements, what we can and can't do. ASA Law School and I are continuing to try to get that resolved. We're hoping on next side.
That's correct. You want to just put him on for the next full cycle?
Yes, Judge.
You said he's incarcerated?
No, Judge, he's in an adult assisted living facility, so trying to
So let's try to figure out whether we do it on the 8th or the 10th. So we'll do it April 8th.
Thank you, Judge. The next case, Judge, is Anicia Giants in 23 CF 423. We left this matter on for a status date. Ms. Giants' appearance was waived today so that we could file the report we received by Dr. McDonald. We have filed that and provided that to the state. And I'll let Mr. Lawson speak.
That's correct, Judge. I did review that this morning. The state's going to be seeking a second opinion. I've spoken with the defense counsel, and I believe she's stipulating to it, so I'll issue an order and we can get that in motion.
Very good. So you want to just so we can keep status on this, you want to come back on 4/8 just to kind of see where we're at?
That's fine. Ms. Merrifield, for the record, I'm very stipulated to that.
Very good. So we will continue that. I'll look for an order. You'll put it by stipulation and certainly continue that.
Thank you, Judge.
Okay, good.
The last case I have is under my name, Judge.
Okay.
That is Sabrina Brief with a G.
Sabrina Brief?
Yes, Judge. It's CF 1428. We have reached an agreement. It is misdemeanor with misdemeanor probation, if I may approach.
Amen. Obviously, the state's signed this.
Yes, Your
agreement.
Honor. And it was,
What's today's date? The 9th?
The 19th.
yes,
Thank you very much.
I believe that's all I have, Judge.
Okay, thank you. Mr. Shaw, here.
Tim Shaw, the first case, Judge, if you allow me to cover for Jason Cobb before I get started on mine, or I'll forget it.
That's all right. Let's do Cobb.
He's got Barry Gassman.
Correct.
The public defender, please, all the way out the hall.
before the court is Barry Gasman, case numbers 21 CF 2971, 21 CF 3043, and 22 CF 2208. Mr. Cobb is asking to leave 21 CF 2971 on for trial. It's my understanding the state is requesting to try that case first.
That's correct, Your Honor. I spoke to Mr. Cobb this morning. I think we're both on the same page with that.
Okay. So we'll come back for a jury review, which is on Thursday the 22nd.
Yes, sir. Thank you.
And do we anticipate two days?
I think so, Your Honor. I think that's what we're talking about, exclusive jury selection.
Very good.
Thank you, Your Honor.
Okay.
Your Honor. Your Honor, Tim Shaw for 79 Allen, 23 CF 1310. We left this on for clear continuance. We've made some progress towards a resolution. We'd like to set it on for, I believe it's 4/8. Should be the last time.
Very good. We'll continue this to 4/8 and ask that the clerk's minutes reflect this will be the last continue.
Thank you. Next is Chance Boyd. Judge, may I approve?
You may.
Judge, before the court is Chance Nicholas Boyd in 22 CF 2090F. At this time, Mr. Boyd would withdraw his previously entered plea of no contest, tender a plea of, of not guilty and tender a plea of no contest to the amended charge of carrying a concealed firearm, which is a third-degree felony. Adjudication would be withheld, 36 months probation, 6
So is this a lesser included? Or
Yes,
no?
it is a lesser included.
Go ahead. 36 months probation, 615 in court costs, 50 hours community service work, which we asked that he be allowed to buy out at the statutory rate. Maintain gainful employment or complete 2 job applications per week. There would be early term at 18 months provided no violations and all conditions are met.
One thing, I think the clerk needs the statutory cite for the downward departure. Or not for the downward, but for the lesser included charge, the new charge.
79001.
We can put it in here.
From the statute number?
Yeah, the statute number.
I think it's 790.
It's gonna be 79001, and it's gonna be subsection 3.
Yes, sir.
Mr. Boyd, would you raise your right hand, sir? Do we have a score sheet on this?
Your Honor, what was the court score sheet? I had to amend the charge.
Is this a downward departure?
No, Your Honor, we're not.
Mr. Boyd, again, raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so Mr. Boyd, you heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement that you signed.
Yes, sir.
Have you read this closely?
Yes, sir.
Have you gone over it in detail with your attorney? Make sure you had all your legal questions answered about it?
Yes, sir.
Importantly, as you know, you're waiving the right to go to a trial and, there are basically constitutional rights. You're waiving those in order to get a final resolution of this today. You believe that's in your best interest?
Yes, sir.
Okay, and you believe that you have had all your legal questions answered by your attorney?
Yes, sir.
And you believe this is in your best interest?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept this plea agreement. There'll be a withhold of adjudication. And there'll be the lesser included charge of carrying a concealed firearm, which is a third-degree felony. And the court will sentence you at this time for 36 months probation with the court costs that are contained in the agreement. In addition, as conditions of the probation, you must complete 50 hours of community work and maintain gainful employment or applications. And you do have the right to have early termination in 18 months, basically halfway through, if you provided that all conditions have been met and there's been no violation. Okay? Any questions?
And that's a withhold, Judge. I don't know.
That's a withhold. I did say that.
Okay.
Yes, that is a withhold.
Thank you.
Thank you.
Judge, the next case is Nathaniel Fannin. This is case 23 CF 1505. We have left this on for clear continuance as well. The state and I have had some discussions. It looks like this may be referred to a diversion program. I think the state's going to be providing me some information with regard to that. So if we just put it on, I don't know if you want to do a full continuance or you think about do the March date.
I think a full continuance would be appropriate. I've let Mr. Shaw know that I'll send him an email explaining what mental health court is and how his client can be evaluated for it. One cycle would be sufficient.
Okay. So we'll continue till 4/8, April 8th, and hopefully you qualify for the other program and be beneficial.
Next case, Judge, is John A. Geiger, that's 23 CF 695. There is a waiver on file. Mr. Geiger is a resident of California at this time, and he's getting some treatment out there. I provided that information to the state. We have not been able to resolve it, but I would ask that we go on for it.
I would agree for it would be appropriate. Mr. Shaw and I have to talk about this case a little more. I did see a recent filing.
I'm sorry?
He sent me some information I need to review.
Okay. We'll continue this matter until April 8th.
Jerry. And the last case, Judge, that I have on the docket is Jerry Lee Hollingsworth, that's 22 CF 1975. We left this on and looked for the resolution as well. We were unable to resolve it, and we trial on the next side.
We'll continue this till 4/8, and if the court, if the clerk's minutes can reflect, this will be the last meeting.
Thank you, Judge. That's all I have.
Okay, thank you. Mr. Flyer, are you ready?
Your Honor, I am.
Good morning.
Good morning, sir. Your Honor, Casey Craig should appear on your docket. Your Honor, we're here prepared to withdraw his previously entered not guilty plea and enter a plea of no contest. Judge, do you have that case number?
The case site is
Yes, sir.
23 CF 455.
Yes, sir, it is that case. But at this time, Judge, he would withdraw his previously entered plea. And I've gone completely and thoroughly through the plea and sentencing agreement, which calls for as follows: adjudication of guilt to the 3-count information. The agreement with the state is as follows: that he would be placed on 2 years probation concurrent on each count, statutory fines and costs. The cost of supervision while on probation would be waived. He would be ordered as a condition of probation to perform 50 hours community service work or to pay for those hours at the statutory rate. He would have no contact with the victim in this matter, Richard Gostomski. He would not trespass at Cash America. He would maintain gainful employment, and in the event there were periods of time when he was unemployed, he would provide 2 job applications per week. He would take an online anti-theft course as a condition of his 2-year probationary sentence, and I believe that's the complete agreement with you.
That's the state's agreement, and then on count 1, the defendant is pleading to constructive possession of a firearm by convicted felon. It is not the actual possession. So the 3-year minimum mandatory does not apply to that.
And Your Honor, I apologize for not announcing that. That's absolutely our understanding. Okay. Count 1 is constructive possession. Do you have a plea agreement?
Charles, would you approve?
Yes, sir.
swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes, Your Honor.
And Ms. Sharpless, did you say that Marcy's law had been compliant?
Yes, Your Honor, I did speak with the victim. He did understand it.
Okay. So, Mr. Craig, you did hear your attorney state in terms of the plea agreement, and I see that those, you have signed the plea agreement, let me make sure of that. You did. So, the first question is, did you read this closely?
Yes, Your Honor.
And did you go over it in detail with your attorney, make sure you understood all the legal nuance and all the legal ins and outs of the plea agreement?
Yes, Your Honor.
Importantly, you're waiving some valuable constitutional rights, right to go to trial, right to confront witnesses, all of that. You believe that that's in your best interest to resolve this matter totally, but waiving those rights?
Yes, sir.
And you have had all of your legal questions answered by your attorney?
Yes, sir.
And you believe it's in your best interest to enter into this plea?
Yes, sir.
Very good. Based upon that, the court will accept your plea agreement. And as to all counts, each count, the court will sentence you to 2 years probation. And I am assuming that these are all, for sure, these would be concurrent.
Yes, sir.
So each of the 3 charges would have 2 years probation. They would all be concurrent. We'll probably need to stick that in there. You got 50 hours of community service, no contact with the victim, no trespassing. You've got the terms and conditions that are contained in here. You must maintain gainful employment and take an theft course. Obviously, the standard fees and costs. You will waive cost of supervision.
No.
If you just put in there just the probation right after that, just say concurrent.
Just in front of head, and I apologize for that. But
That's all right. Thank you. Mr. Craig, any questions, sir?
No, Your Honor.
Thank you.
Thank you.
Thank you, Mr. Clark. Ms. Dudley?
First one I have is Trayvon Harris, 23 CF 1366.
Okay.
Can we set this today for Peter C? Can we leave this set for Thursday for status? The state made a misdemeanor offer. I'm going to recommend you take it, and I'll have court here Thursday, so.
Will that be a plea or continue on?
Yeah, but is it
You're anticipating it will be a plea?
Yes, sir.
Okay, we'll continue this to for jury review, which is 2/22 this Thursday
Yes, sir.
at 9 a.m.
The next case I was committed is William 21 CF 1406. We were just set today for a status. The state has provided me with the photos of those drawings from the case. So we just need to continue it one cycle, I believe.
I think that would be a perfect instead of an opportunity.
Very good. So we'll continue this matter, and assume he's not in prison, not in jail.
Correct, it is a waiver.
We'll continue it till 4/10.
Yeah, the next one I have is Jerry Reed, 22 CF 96 and 22 CF 654. We were set today for status. In one case, to get a missing video. We did get one of the videos. I have not actually had a chance to review it yet, but I did get it this weekend. And then in the other case, we're waiting for a witness to the address, and I did get a new address for that as well. So we'll ask for petition next cycle.
State?
That's correct, Your Honor.
We'll continue both of these matters till 4/8.
Now, I believe that's all I have.
Thanks, all you got. Thank you. Appreciate it. Mr. Swanton.
Good morning, Your Honor.
Mr. Swite, I skipped over Mr. Durrell, but we'll do Mr. Swite, we'll do that. Check, sorry. Mr. Swite.
Your Honor, I'm here on behalf of Abraham Evans, Glenn Switek for the record. It's 22 CF 1454.
Hold on just a second. Very good, sorry.
Your Honor, in this case, we concluded depositions last week, and Ms. Sharpless has stated we could have until March 14th for him to make up his mind on some issues. One of those, he tells me today he does want a written copy of the depositions for his review. And I can get this to him shortly.
Okay.
But anyway, if we can have that March 14th date.
Okay. We'll continue this until March 14th.
And on that day, Mr. Collins.
Can we do the 19th? We're kind of stacking up on the 14th.
You're going to do the night, March 9th.
Is that okay?
Let me double
If you
check.
really need it on the 14th, we can put it on there. Go
Well,
on.
it might work better for me actually, because I'll be on the plane on the 14th.
Well, that would probably be better than to do the 19th. You're going to be on a plane on the 14th or the 19th?
I'll be on a plane on the 14th. Mr. Collins is going to cover.
Why don't we do 3/19?
I can do 3/19. I'll be back on the 18th.
Okay, very good.
All right, thank you.
Thank you. Mr. Durrell.
Thank you, Your Honor.
Sure.
May it please the court, Justin Durrell. Your Honor, if I may call Mr. Dennis Gomez Machado first.
Okay.
Good morning. Machado. We do have a written plea. I just need
Madam Clerk, would you swear the interpreter?
Yes, Your Honor. Please state your full name.
Teresa Iribarren.
Do you agree to accurately translate from English to Spanish and from Spanish to English the matters brought before the court, so help you God?
I do.
Thank you.
Thank you. And Your Honor, I have gone over the terms of the plea with Mr. Gomez Machado with the help of Ms. Teresa. I do still need him to sign it though. I may approach.
Mr. Durrell, would you announce the terms of the plea and go a little bit slower so that the interpreter doesn't get a good interpretation?
Yes, Your Honor. At this time, Mr. Gomez Machado would withdraw his previously entered plea of not guilty and enter a plea of no contest in case 23 CF 1833 to the charge of possession of controlled substance. In exchange for that plea, the state is dismissing case 23 CF 1834. There was also a victim request to drop charges in that case. The understanding is that Mr. Gomez will be placed on 2 years probation in the 1833 case, standard fines and costs, substance abuse evaluation, and any recommended treatment. I believe it's scheduled within 30 days, start within 60.
So we have the fees and costs that are outlined in here. I'm seeing that.
I did not know the fees and costs offhand. Madam Clerk, do you know what the fees and costs for a 615?
And does the state comply with launches?
Your Honor, with regard to the battery case, it's a statute of limitations issue. We have no contact information for the victim, but we have no choice but to dismiss this because we can't pursue it lawfully.
Okay, very good, thank you. Senor Gomez, you heard your attorney state the terms of the plea agreement. And those same terms are contained in the written plea agreement. I know the written plea agreement is in English, but did you get a chance to review it with the help of the interpreter?
Yes, Your Honor.
And do you believe that you understand the terms of this plea agreement? Importantly, this plea agreement contains a waiver of a number of rights that you have. The main one is the right to go to a trial, to force the state to prove their case beyond every reasonable doubt. You're waiving that right in order to get a final resolution here today. Is that what you want to do? You believe that's in your best interest? And even though you've got some language barriers, do you believe you've had all your legal questions answered?
Yes, sir.
Okay, very good. Based upon that testimony, the court will accept your plea agreement. And the state has agreed to dismiss 23 CF 1834, that's the ag battery charge. And you're pleading, there'll be adjudication of guilt on the possession of controlled substance. And you're sentenced to 2 years probation with $615 court costs, and a condition that within 30 days you must do a substance abuse evaluation. And if they tell you need to take some classes, you need to start within 60 days. Do you understand? Any questions? You have 30 days to appeal this. You must report immediately today, or if you can't, if it's too late today, first thing in the morning in probation. Do you know where that is? 15 Kelly Drive?
13 Kelly Avenue.
You only said that one. I don't know where 15 came from. 13 Kelly.
Thank you, Mayor. Appreciate your help. Now, next is Mr. Dylan Aspel. This is everything we spoke about. We went over with you for years. And Your Honor, I did speak with Mr. Aspel about this. I believe it was Friday. I'm just confirming this is. He did ask me one more question about the state. I did speak for this morning, and they are sticking with the adjudication. So if that's still okay, everybody signed it. If that's what you want to do. No, that's statutory. That's pursuant to the family law court and the injunction. Correct. Correct. Yes. And Your Honor, we do have a written plea agreement, if I may approach.
You may.
This is 219.
Would you please announce the plea?
Yes, Your Honor. Pursuant to agreement with the state, Mr. Asbel withdraws previously entered plea of not guilty, enter a plea of no contest. Your Honor, on the fleeing and elude, he will be sentenced to 3 years probation. It is adjudication of guilt. The count 2 is the driving while license suspended. That is 6 months probation. It is a 1-year driver's license suspension. I believe that one requires and Your Honor, let's see if I did not give myself another cover sheet. That one, I believe, is going to require the substance abuse evaluation and any recommended treatment. The aggravated battery case is going to be a plea to the lesser included of misdemeanor battery. That is 1 year probation, and all of these counts and cases are going to be concurrent to each other, Your Honor. That is no contact with Ms. Courtney Hyatt, except according to the family law and injunction. They share children together, and I was party to the injunction hearing where Judge Stone allowed contact through, I believe it's the Parents Close app, or Close Parents, or something along those lines. It's a third-party application that allows for recorded communications. And they are to only communicate about the children and exchanges and medical and so on and so forth. So there is communication between the two as far as that is concerned. But other than that, no communication between Mr. Aspel and Ms. Hyatt. The violation of domestic violence injunction will be 1 year probation, and same terms and conditions as the misdemeanor battery, of course. There is a batterers intervention program that is required pursuant to the lesser included misdemeanor battery. I believe that was everything, Charles.
And Your Honor, that violation of domestic violence injunction is a county court case.
We would stipulate
I
to the
spoke to my
court's
colleague
jurisdiction.
and she was okay with the signing plea agreement. The court will accept the plea on.
I'm sorry, say that again?
The violation of the domestic violence injunction.
That's what Mr. Gotcha.
Yeah, it was a county court case, but Ms. Turner, I asked Ms. Turner if she would be okay with us adding it to this plea agreement. She was fine with that. The court would accept the plea.
One, just clarification, it doesn't have any substantive change, but the substance abuse evaluation and treatment is contained in the 23 CF 1873, the lesser included misdemeanor battery.
Yes, sir.
You just said it was the first one in, but it doesn't have any substantive. Okay, so state that the agreement.
That's the state's agreement.
Mr. Aspel, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of your plea agreement.
Yes, sir.
And I see that those same terms are contained in the written plea agreement that you have signed. Have you read this thing closely, this agreement?
Yes, sir.
Have you gone over it in detail with your attorney? Make sure you have all your legal questions answered. You understand you're waiving some valuable legal rights in order to get a final resolution today.
Yes,
I
sir.
believe that's in your best interest.
I do, sir.
Based upon that testimony, the court will accept your plea agreement, and the court will sentence you as follows. This to count 1 in 23 CF 1738, which is fleeing and eluding. It will be an adjudication of guilt as charged. The court will sentence you to 3 years probation, standard fees and costs, etc. Count 2 of that charge, which is the driving out is suspended. You're to receive 6 months probation, 1 year driver's license suspension. And then the third charge, it's actually the second case, but the third charge, 23 CF 1873, is to count 1. It's a lesser included of misdemeanor battery. It was aggravated battery. It's down to a misdemeanor battery. And in that case, you'll be sentenced to 1 year or 1129 probation. And as a condition of that probation, will be no contact with Courtney Hyatt except as allowed by the family court and pursuant to the current injunction. Okay, and you must abide by that current injunction. That's a strict stay away order. Well, I mean, the way it's worded here, it's a little tricky. When you have these different areas, family law, injunctions, criminal law, all kind of meeting in the middle, it can be one of the trickiest areas of the law. So all I would say to you is you have to abide by the family law as well as the injunction, and that actually is a condition of this. So if you violate the injunction, you could get in trouble over an injunction and they could violate you here. Okay? It's just kind of an emphasis to, hey, take this serious. But it looks like, and I'm not telling you how to do it, but the family law is different than the injunction. Can be different. The injunction is generally a strict no contact. But I think you've got the same judge on your injunction as you do on your family. Judge Stone is on both ears?
Yes, sir.
Okay. So he's very adept at kind of navigating those cases when they're in two different areas. So assume that will be clear to you. But you just need to pay attention to that.
Yes, sir.
Then you must include participate and complete battery intervention program, and substance abuse evaluation must get eval in 30 days and start treatment in 60. And then the last case, which is a misdemeanor violation of the injunction, when the new charge was filed, you'll be sentenced to 1 year probation, and all of these probationary periods will all run concurrent. So it's basically a total of 3 years. Okay. So, questions?
No, sir.
Very good. And you do have, even though you just entered into this, you do have 30 days to appeal.
Yes, sir.
Thank you.
Thank you.
Our next, Mr. David Cowart. Your Honor, I'd like to request a continuance of Mr. Cowart's case, and this should be final. We essentially have a plea agreement. There's one final issue, Mr. Cowart's driver's license, that we're trying to resolve. So I would just request.
It seems that Mr. Cowart is in, no, it's out.
No, Mr. Cowart is not.
It's critical. So you just want to come back at the, on 4-8, or you want to do a miscellaneous in between?
I think 4-8 will be more than enough time, and if we get the issue resolved before that, I can contact your office about trying to move him up to the third.
Okay, very good.
Your Honor, next on my list is Mr. Frank Dixon. Your Honor, we do have a plea agreement on Mr. Dixon. I don't believe I have not seen him today, and I was not able to reach him this morning. I know we announced ready for trial, but we do have a plea agreement now that Ms. Taylor, Ms. Sharpless, and I discussed after we had announced. If we want to leave him set for this Thursday, I'll make sure I communicate that, or I'll leave that one at the court's discretion. But I don't believe
let's get it done. We'll do it on jury review on the 27th, 9 a.m.
And that one is my fault, Your Honor. I apologize for that.
That's all right. I've got one other one. Oh, yeah, Caden Bennett.
Oh, yes, Your Honor. I'm sorry, I didn't bring his file because we did get the signed PTI back. I provided it to him, told him he needs to take that to probation.
Okay.
When probation signs off on it, I'll make sure that gets filed with the courts so that he drops off the docket.
Very good.
Next, I have Miss Dana Jackson.
Dana Jackson.
Who set that up for control?
Which one?
Can we move him to 4-8 until drop off?
Good. Thank you, Madam Clerk.
Thank you, Ms. Clerk. Ms. Dana Jackson, Your Honor, I have reviewed the plea agreement with Ms. Jackson as well. I do need her to sign it. So just like we spoke about, they're dismissing these counts, the introduction and the paraphernalia, 2 years, concurrent and coterminous with what Mason did. Okay. So they dropped 1, 2, 3, and 6. These are the ones that the motion would not get us to that we spoke about. This is the introduction. So you're pleading no contest to that. You're okay. So this is the adjudication. You're pleading to those two. And Your Honor, I need Mr. Walsh to if I may approach, Your Honor?
You may. Would you please announce the plea agreement, Mr. Duro?
Yes, Your Honor. At this time, Ms. Jackson will withdraw her previously entered plea of not guilty and her plea of no contest to counts 4 and 5, the understanding that the state will dismiss counts 1 through 3 and count 6. Pursuant to the agreement, Ms. Jackson will be sentenced to 2 years DOC. And Your Honor, it's the intent of the parties here that Ms. Jackson's sentence in this case will be concurrent and coterminous with the, and Your Honor, I don't remember the numbers offhand.
It's in here. It's 22 CF 535 and 22 CF 957. Well, no, that's not true. Anyway, here, look at it, make sure. It's just a little bit unclear whether you got the termination.
Yes, Your Honor. It is concurrent and coterminous with 22 CF 535 and 22 CF 957.
Okay.
Yes, Your Honor. It's both. And essentially both of those cases, just to give the court a little procedural background, Ms. Jackson had been in
I'm going to ask you one other question.
Yes,
You're
sir.
going to take it. Keep talking, but
I'm sorry.
I'm going to have you put something in. Go ahead.
Ms. Jackson was in Veterans Court and was essentially failed out of Veterans Court. The sentence was 2 years DOC. While we were awaiting the hearing for that, they heard these new charges. When she was sentenced to the 2 years DOC, I was still receiving discovery on this case. It was negotiated that essentially this case would be wrapped into the other one, but it's taken so long to get the discovery of my review and to get the depositions and everything. A considerable amount of time has passed. That's why we wanted to do it concurrent and coterminous, because it's the intent that the end date for this sentence will be the end date for the 2 years Judge Mason imposed on the failure to complete the vet court sentences, and that was the 22 CF 535 and 22 CF 957 cases.
The one little point of clarification I was going to bring up is that the 2 year sentence, I think, would be for each of the charges, and then they would run concurrent. We have to put sentencing for each charge.
Okay.
I assume that's what you want to do. You want to just...
Well, the count 5 is possession of paraphernalia, so I would ask if this is fine on count 5 and then 2 years on count 4.
Why wouldn't you just do the 2 years on everything?
On count 4 and 5? Because count 5 is possession of paraphernalia.
Correct. That's fine. So you can do credit for time served on count 5. And then,
Okay.
Right. I'm fine.
Just really a point of clarification.
Thank you, Judge.
Yes. Thank you,
It
Your Honor.
doesn't change the core of your plea agreement. But we have to have a sentence for each charge, and they're separate even though they're running together. Okay, ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your
So
Honor.
you heard the terms of the plea agreement that your attorney announced, and I see that those terms are contained in the written plea agreement. Have you had a chance to read this written plea agreement closely?
We talked about it.
Okay, and that was my second question. Have you gone over it in detail to make sure you had all your legal questions answered?
Yes, Your Honor.
Okay, because there's a lot of, there's the core of your plea agreement, but there's also a lot of other legal stuff in here. The main things is that you're waiving a number of basic constitutional rights. We don't think about it, but when we come to the courtroom, we're dealing with constitutional rights every day. And the main one is the right to go to a trial, your jury, your peers, the right to confront witnesses. All those things you're waiving in order to get a resolution. Is that what you want to do here today?
Yes, Your Honor.
You've gone and had all your legal questions answered by your attorney?
Yes, Your Honor.
You believe it's in your best interest to enter into this plea agreement?
Yes, Your Honor.
Very good. Based upon that testimony, the court will accept your plea. The state's in agreement? Yes? No?
That's correct, Judge.
Okay. And so, as to counts 1 through 3 and count 6 in 23 CF 1912, the state's going to be dismissing those, null dismiss. And as to the remaining counts, counts 4 and 5, there's an adjudication of guilt as charged. And as to count 4, which is the smuggling of the contraband, you're going to receive 2 years Department of Corrections, standard fees and costs, and that sentence would be concurrent and coterminous with 22 CF 535 and 22 CF 957. And as to count 4, you'll get credit for time served.
Your Honor, I think you meant to say as to count 5.
Count 5.
Count 5 is just time served, that's the paraphernalia charge, Your Honor.
Okay.
Credit for time
Count
served.
4, 2 years. I think that's superfluous. You already put it.
I believe it may be, Your Honor.
What did you write down here? I'm having a hard time.
If it's coterminous, I don't believe the credit for time served is going to matter on this one, but I always hesitate to waive any time served. But and I don't know when the end date for the 22 CF.
You said count 4. Make sure I'm not following what you put in here.
Okay.
So I'm just not reading it right.
On counts, so it was originally written as counts 4 and 5 as charged. 2 years DOC. I broke that out in the bottom to say count 4, 2 years DOC, and count 5 is time served. The standard fines and costs for counts 4 and 5. At this point, count 5, it doesn't matter if it's concurrent or coterminous, that's time served, we're done with count 5. So just count 4 is going to be concurrent and coterminous with 2022 CF 535 and 22 CF 957.
And that's the key thing.
That is the key.
That's the key thing.
That's the crux of
Make
the
sure we
agreement.
put it. Very
Yes,
sure.
Your
Okay. So any questions, ma'am?
No, Your Honor.
Okay. And you do have 2 years to appeal this, even though you just entered into this agreement.
We're getting the time and date of the costs.
Yes. How long after she's released to pay any fees and costs?
We would ask for 180 days.
180 days. That's important. If you can get those things paid off, then we'll get your driver's license and try and knock that. Okay? Thank you.
Thank you, Your Honor. I do believe that's everything I
I
have
think
to
it's
say.
everything you got. Thank you.
Thank you.
Mr. Friedman?
Good morning, Your Honor.
Good morning.
For Freeman, on behalf of Kelly Drummond, she's the person on case 23 CF 1568. Let me change your plea, Your Honor.
Okay.
My client withdraws her previous plea of not guilty and there's a plea of no contest to the amended charge of interference with child custody.
If you by any chance have an extra copy I can be reading while you're...
Yes, sir. May I approach?
Sure. Thank you.
Yes, sir.
Okay, why don't you start over?
Yes, sir. My client withdraws her previous plea of not guilty and there's a plea of no contest to the amended charge of interference with child custody, subsection 787.03. The negotiations with the state, the special conditions are as follows. She'll have her adjudication withheld. She'll have 60 months of probation. No contact with the victim whose initials are BB. She'll consume or possess no alcohol. She'll have to complete alcohol counseling and follow recommended treatment. She will also have to complete sexual offender counseling. Court cost fees and fines of $550. I have signed as well as my client and the state. Sorry, no, Your Honor, I thought it's on the plea form. It's no unsupervised contact with anyone other than her own children up to this point.
And you also said no contact. You were saying stuff that's not on this plea, correct?
The no contact with the victim is checked off. It's DB. It's his initials. It's one of the pre-printed.
Contact the victim correctly. Who is the victim in this case?
The initials are DTB, date of birth 6/22/0.
remaining charges are dismissed, which
They will be, Your Honor, and we'll have to file the amended information on the first count, but it'll be the first count of interference with custody, 787.03, as stated by Mr. Chairman.
go ahead and put in all pros the other 3 or 4 counts, 2 through 5. You'll put that on there, Council.
Yes, sir.
It's going to be 62207.
Thank you.
Okay. So, Ms. Drummond, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement that you signed. So my first question is, did you read this closely?
Yes, sir.
And did you go over it in detail with your attorney to make sure you understood all the legal implications of this plea agreement?
I did, yes, sir.
And you had all your questions answered?
Yes, sir.
And you believe it's in your best interest because you're waiving some valuable legal rights by agreeing to this. Do you understand that?
I do.
And you believe it's in your best interest to do that?
Yes, sir.
Very good. Based upon that testimony, the court will accept your plea agreement. And the state is going to be null processing counts 2 through 5, correct?
That is correct.
Well, correct for the whole plea agreement. You're in agreement?
Yes, sir, we are agreeing with the plea agreement.
And Marcy's law thing?
Yes, Your Honor, we did speak to the victim's mother and the victim, and they are agreeing with this.
And the court will, on 2 weeks. So the count 1 will be amended to be a charge of interference with child custody. That will be the sole charge here today in the statutory cites in the agreement, Madam Clerk. The court, based upon the dismissal of these and the change in the charge, essentially is 60 months probation. And as a condition of that probation, there's no alcohol use and no contact with the victim and no contact, unsupervised contact with any minors other than the defendant's own children and the other standard terms and provisions, including fees and costs that are contained. Okay, any questions, ma'am?
No, sir.
Thank you very much. You do have 30 days to appeal.
That's all I have, no excuse.
Thank you, Mr. Chairman. Who's up there? Who's? Sorry.
Your Honor, we'll also be providing the correspondence portion for that when we file the information.
Thank you. Counsel?
Good morning, Your Honor. Dustin Marsher on behalf of DeMarcus Smith. That's case number 23 CF 1162. Your Honor,
whose name is it under?
It should be under Attorney Tony Henderson.
It's under Henderson.
Yes, Your Honor.
There was another one I forgot what it was.
Your Honor, there was a motion to continue file on the 16th. It was stipulated to by the state. There is also a waiver on file for Mr. Smith. I believe it was filed as of this morning. And I believe the state was going to notify the court of the reasons of the continuance.
Sure. Judge, you guys announced clear trial.
That's correct, Judge. Last time we were before you, I let the court know I went through discovery and made sure that everyone was disclosed. I did a discovery that day. Mr. Marsher was aware of it. He told me that he would review it and let the state know if for some reason he was going to have to conduct a deposition of any people I disclosed. The state's position is that the defense should not be surprised by these names because they were in the office report that was sent in discovery. I believe 2 of them are purely chain of custody witnesses. 1 is the booking officer. However, the state understands that the defense needs to, and believes it needs to depose these officers. The state will stipulate that continuance.
Okay, is this the last continuance?
The state would ask for it to be the last continuance, Judge.
I have no grounds to object to that, Judge.
Court will continue this matter until April 8th. And we'll ask that the clerk's minutes reflect the license.
Thank you, Judge.
And he's in custody, sorry.
Your Honor,
April 10th, thank you.
the state will also prioritize this case and give deposition dates to Mr. Harsher.
Thank you.
Thank you, Your Honor.
It's being incarcerated.
This is the one that we have a problem with.
2 days.
Yes, Your Honor. And we're still in the process.
You're going to get that corrected by the next time you problem?
I can't make any promises, Your Honor, but
It's out of your control, just kidding.
all my attempts have failed so far. So.
Just so the court's apprised, I did reach out to Nathan Daniel, who is negotiating at the jail to see if we can get this corrected.
Okay.
I appreciate it. I mean, it's just hard on everybody. We're trying to get it.
Yes, Your
If
Honor.
he has constitutional rights to be here, you know,
And when he did get transported on the 14th, I did get to talk to him before he got called up, and he's aware of the circumstances.
Okay, very good, thank you.
Yes, Your Honor.
Mr. Dees?
Good morning, Judge. I've got Keontae Pride. Okay. Before the court, 22 CF 1196. I'm looking at Ms. Graham's cases, traveling along with this one today. I will cover from Ms. Graham, who's in the North End.
Hold on a second, hold on. Ms. Graham?
She's in the North End, Judge.
Are you handling both the cases?
I'm going to handle hers because hers is going to be a continuance. Mine is going to resolve this morning if I may approach.
Okay.
And Your Honor, that was the state's understanding, too. Ms. Graham did notify me that Mr. Dees would have to cover for her.
So that was, Ms. Graham's case 23 CF 326 is continuing to the next cycle?
Yes, Your Honor.
Thank you.
So we do not need Mr. Pride out?
He's here.
He's here.
Praise out.
The other one is for Ms. Graham.
We'll go ahead and continue that.
Got two different names.
There's two cries.
Got two different names.
Yes.
Two different guys.
Yes.
This is two cases. This is Keontae.
Well, so I got Jamarian as an inmate.
Yes.
Right.
That's
This
not,
is Keontae.
And we
we're
don't.
not dealing with him right now. We're just dealing with Keontae.
That's what,
Yep.
We work
Keontae has two cases. One with Mr. Dees, one with Ms. Graham. Ms. Graham's case is being continued, and now he's dealing with this case.
I see why you're asking though if he needed to be present, but I guess he's going to let him know that his case is continued. I circle around and let him know. But as far as Mr. Pride's case, in 22 CF 11936, Judge, he's going to withdraw his previous enter plea of not guilty, tender one of no contest. He's going to enter a plea as charged in count 2, which is a misdemeanor offense. We're going to ask him.
Do you by any chance have an extra copy of the contractual law you're saying?
I do, Judge, actually, I think
Oh, you just gave it?
I gave it to you, yes, you did.
Start over again.
No problem. So in 22 CF 11936, he's going to enter a plea as charged in count 2, the first degree misdemeanor. As to count 3, he will plead to a lesser included offense of discharging a firearm in public. That statute number is 790.15. That too is a first degree misdemeanor, punishable by 1129 county jail and a $1,000 fine. Mr. Pride is a juvenile. He did not sign the waiver of the PSI, so we're asking the court to order a PSI. My understanding is this case will be passed and set for sentencing upon resolution of his pending case with Ms. Graham. The score sheet will not apply as these are misdemeanors.
That's correct, Your Honor.
Okay. Is that the right case number, 11936? When did we have a 5?
You know what? It may have been the agency case number getting juxtaposed on there.
I'm sorry.
Let me announce it on there, Judge, and I'll change it on yours. It is 22 CF 2486.
That's correct.
My apologies. I was announcing it wrong. Thanks. 2486. Had a lot of cases in 22. 2486.
Yes, 2486, 22 CF 24.
The record year in 22. And with that, Judge, he's tendering a plea of no contest.
the state in agreement?
Yeah, yes, Your Honor.
And the state's now saying null process of count one?
Yes, Your Honor. The victims elected not to participate in that charge. And Mr. Pride is claiming the charges that the state does not need the elected victim to participate. This is the reason for the agreement, Your Honor.
And will withhold so the adjudication of guilt is at the discretion of the court. So we'll just wait on those we'll wait on the sentencing for those. We'll include that in the sentencing. So Mr. Pride, would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Pride, so you heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement. I want to make sure you sign this. There he is. I found him. I just want to make sure I find your signature. Okay, so I see you signed this as well. So have you read this plea agreement closely?
Yes, sir.
Have you gone over it in detail with your attorney? Want to make sure you had all your legal questions answered about that?
Yes, sir.
This is a little bit of a unique situation because you're basically agreeing to the first part of the equation. You're agreeing to the plea. You're pleading here today. You're pleading no contest. And what that means is that you're waiving the right to go to a trial. That's a valuable legal right, the right to confront with all those things you learn about in civics class. Okay? You're waiving those in order to get a final resolution in this case. And you believe it's in your best interest to basically plea this to the bench.
Yes.
In other words, leave it in the hands of the judge. However, your attorney's going to be able to argue and will argue on your behalf, and you might actually testify yourself if you all decide to do. The state's going to argue the other side, right? They're going to argue for something else. You understand that? You can't, at that point, you can't say, well, gosh, I didn't think I could get that bad of a term. You can't back out after that. You understand that?
Yes, sir.
You believe this is in your best interest to do this?
Yes, sir.
Why? Why do you believe it's in your best interest to do this here? Just in your own words. Why are you doing this? Why do you feel? The main thing I want to do, I want to make sure that you're doing this freely and voluntarily.
Yes, I am.
I don't want you, you're a young guy. You're not, you're a young man. And I don't want you have a right not to be coerced. You know that word? You know what that means? Nobody's here twisting your arm. It's got to be something you want to do after meeting with your attorney. Not the other side, your attorney who's advising you. Okay? You believe it's in your best interest to do it this way? It's better for you to do this way than that? I'm sure they offered an actual deal that included some type of a rigid sentence. But you think it's better to do a plea to the court, a plea to the bench?
Yes, sir.
However you want to call it. Okay. Do you have any questions concerning the plea agreement?
No, sir.
Okay. Very good. Based upon defendant's testimony, the court will null pros count 1, 22 CF 2486. And as to count 2 is as charged. Count 3, it's the lesser included offense of disarming a firearm in public. And both of those charges will be set for sentencing. And the court is requesting a PSI, sentence investigation. They'll go through some things, and the adjudication of guilt will also be dealt with at that sentence. Council, question, anything? Did I miss anything?
Yes, sir. Any questions?
Any questions? Thank you very much, and it'll be, how long do we need? We're gonna have to sentence it, we gotta coordinate with my office, with my judicial assistant. But it'll be, how long do you all need?
We request at least 30 days.
Sure. So when you all do it, it should be at least 45 days.
So just to keep track of Mr. Pride's 2486 case, I was suggesting that it continue to track along with the trafficking case since he will be sentenced upon disposition of that case. If the court would mind, so that way we have a rigid schedule that we can keep Mr. Pride's
Sorry,
case.
say that again.
Just because now that we don't actually have a sentencing date, we're not sure when we're going to get sentencing because it's traveling along with the trafficking case. I was hoping the court would just keep the 2486 case traveling with the other case, just so it doesn't get lost in the system.
What is the other case that's for next?
It was the one that was just continued to the next cycle.
So you want to set this on the next cycle?
I just wanted to travel when it goes, so
The only problem is when it goes to this next cycle, where it's one of those days where, you know, we've got literally 250 short hearings. We can't put a sentencing in the middle of that.
Do you want to set it out for a sentencing date for 60 to 90 days and see if we'll be ready in 60 to 90 days for sentencing? That way we're not clogging up your docket days.
I think that would work. And then if we need to continue the sentencing, we'll let the court know that.
Do you want to just come back on it, just kind of more or less
Smaller date, so you're...
status, or, you know?
Yeah, just do that. On a miscellaneous date, if you have it available.
Yeah,
miscellaneous date.
okay.
Yeah, that'd be
We can
great.
come back next month on March 19th.
That'll be fine.
Okay, now it'll be just a status to coordinate the sentencing and the coordination of both.
Yes, sir.
Help get the PSI done too. Thank you, Judge. I appreciate it. You have a good day.
Thank you.
Appreciate it.
Gilbert.
Morning, Your Honor.
Morning, Gilbert.
Michael Gilbert on behalf of Joseph Carroll and 23 CF 1357. We have a waiver on file. We've agreed to terms. We had hoped to clean this today, but what we do is set it for miscellaneous docket day if I can.
How close are you all to getting it done? Can we get it done on jury review this Thursday? I want to get these things off the books. If you guys are in agreement, let's get it
We
done.
can do Thursday afternoon.
Morning.
Or morning, yes, included.
State, is that all right?
Yes, sir.
So 222 at 9 a.m.
Thank you, Your Honor. That's all I have.
Thank you. No.
Brittany Brown, 23 CF 13.
Yeah, I can leave on this one.
Miscellaneous day.
We'll leave it on 319,
Okay. Continue 319, 9 a.m. without subpoena.
Judge, I then have Andrew Cooper.
He's an inmate.
He's actually here. He got out.
He's out.
Yeah.
Okay.
Yeah, Judge, Mr. Cooper does not want to continue this case. I don't necessarily know that I'm particularly ready for trial, but because of his position, I don't know that I need to announce ready for trial. But I don't think I need to ask for a continuance, but there's a video that he has come into possession of that I believe will help us, but I haven't reviewed it. He told me about it this morning, and the state's not sent me their discovery, I don't believe. But he would like the matter to be left set for trial.
Your Honor, I don't think we announced fair trial on this case.
So what's the state's position?
Your Honor, the state did not issue subpoenas
state wasn't told it was going to be set for trial. Give me just a second, I'll check my notes on that.
There's not time to watch about that. Okay.
And Your Honor, if there is a video that the state is not in possession of that Mr. Cooper does, the state would need to see that video before going to trial.
And I understand that, Judge.
I think for that reason, I don't think we have a choice but to continue. If there's evidence that the defense believes is helpful to the defense, would be adverse to the state, and they would have a right to review it. Yeah, for sure.
Yeah.
So we'll do that, but look, we're ready, court wants to get these cases moving. So we'll come back on our next cycle, we'll look to try and get her teed up if that's what everybody wants to do. 4-8.
Just wait a minute, okay.
Thank you.
Sure.
Judge, I then have Stacy Crowley, 22 CF 656. Judge, Ms. Crowley's having suffered, she's got to have some surgery, heart surgery. And they won't schedule that until we get this case resolved. So I'm asking the state if they're, made a plea offer, but she needs to look at it. What's the next date?
Well, these are kind of unique situation. I'll be glad to deal with it at your review on Thursday. But you guys can feel like, even if you have a chance of getting it done, we can come back. I mean, we're trying to get this lady into surgery. If you don't think you can resolve it,
Should that be great?
let's try it. Let's try it.
Okay.
So we'll continue it till this Thursday, 2/22 at 9 a.m.
Wait a minute, sorry. Judge, I then have Brooke Davis, 23 CF 757. Judge, we're going to have to continue that matter. We had depositions, but they were via Zoom, and the officer didn't have a report and didn't have a video in her possession to testify from. So we'd asked to put it on 4A.
Continue till 4
Judge, we then have Keith Golden, 1 BOP 21 CF 2522, and a new case of 23 CF 2495. So we looked at all about the facts of this case. We're asking the state to consider not prosecuting the new charge under the circumstances. Judge, let's just continue, and I'm going to set the deposition of the officer.
Continue this matter till 4
Judge, then I have Mario Lee. My session is nothing we didn't already have. So, this picture, department.
Did you get the HQ only that goes with it? There was a message, direct message.
I need to know, they know that I asked to.
I'll try to.
Judge, let's just continue it.
The next full cycle?
Yes, sir.
Your Honor,
So-
Mr. Notes did just get a social media download from my office, and he's stating that he was having issues downloading some of the material, so I will get on the phone with Mr. Notes and see if I can resend it and make sure it gets it.
Not to sound like I'm being a little picky, quirky. Why is he just getting immediate download
Because
a
the
case
state-
that's over a year old?
The state just received it, Your Honor. These are the co-defendants, Your Honor. The state does receive the materials, and the state sent it when we received it. Also, this is the case where there's buccal swabs that have DOE, which I don't know if they're inculpatory or exculpatory at this point until they get tested. So
We'll continue until 4:08.
Judge, in the last case I have is William Thornton, who's an inmate.
Thornton?
Judge, Mr. Thornton's got extraordinary circumstances as well. His father's ill, and it doesn't look like he's going to make it. Having said that, if we could put him on for Thursday, just to see if we can get a deal worked out.
Continue this till jury review 222 at 9 a.m.
I'll give you just a second in that room, okay? Judge, I think that's all I've got.
Okay, thank you, Mr. Moses. Have a good day. Mr. Powell. Good morning, Judge.
Morning.
Thomas Cole. 23 CF 851.
Very good.
Mr. Cole's present.
Okay.
Judge, we're gonna leave this on for review, anticipating resolution. The state has made an amended offer, and I can speak with Mr. Cole about that. We're gonna leave it on for review, anticipating resolution on Thursday.
That's exactly what the state is report.
Very good. Continue until 222. Anticipation of the plea.
Very good. Thank you, Judge. We have Stephen Hooper.
Inmate. Hooper. Mr. Powell.
Thank you, Judge. Both out for the record on behalf of Stephen Hooper, 22 CF 1747. If the state not be appropriate.
You may hold slightly. this Thursday, 2/22. That's all you got.
Thank you, Judge. That concludes my business. Thank you, Judge.
Mr. Niddle? And we will take a break after Mr. Niddle before we start with Mr. Harper's cases.
Dexter Lane. I'll do my out-of-custody first, Judge.
Okay.
Ms. Sharpless sent me 20-some videos Friday.
Hold on a second, hold on. So are we on Lane?
Yeah, Dexter Lane.
That's 22 CS 110. I'm
Yes,
sorry, go ahead.
Yes, sir. As we discussed, there are still some outstanding discovery. Ms. Sharpless sent me several hours of video over the weekend. I'm still haven't gone through it, so I'm going to request we continue this to the next court date. We should either be ready. I expect to file a motion to suppress before the next court date.
I know this is not a simple case, but we're 2 years out, we're just getting video?
So, Your Honor, once I became the prosecutor on the case, Ms. Dudley and Mr. Niddle let me know that the previous depositions I had taken, officers had come to deposition and stated that they didn't have video. Ms. Dudley and Mr. Niddle were stating they didn't have it. I've gone through those videos. The video that they were requesting is on the evidence.com link that I sent them, but unfortunately I can't just send them an individual video that I know of, so I had to resend them all the videos. The videos they've been sent should be duplicates, but there should be at least one additional video for the video that they were looking for.
So you found an additional video?
I found it.
2 years later? Or close? Not you, but...
Your Honor, it appeared to me that the state sent them the video originally, but they were stating they did not have it, so I resent all the videos we had.
So can we put on the record this is the last continuance?
I expect it to be so, Judge. As I said, I haven't had a chance to go through all of it.
I would like a definitive answer. Yes, this is the last continuance. Anyway,
Yes, I expect
we're 2 years out. Your client deserves to have a resolution. It's not just the state. This is 2 years out.
I understand,
So
Judge.
I'm going to announce the last one. We'll continue this matter till 4/8. Let's see where we're going with this case. I assume there's been an offer on the table with pretty serious charges, so probably not.
No.
Am I correct? Is there an offer on the table?
Your Honor, it's the minimum mandatory, and there's an offer sheet that is sent with every case.
Okay.
So
I just wanted to make sure that.
I don't have an offer sheet.
Well, I will resend all these.
Give Mr. Nettle the offer sheet, okay?
I don't think Mr. Lane's interested in having
That's fine, that's fine, he has every right to go to trial, but let's go to trial,
I understand that.
okay? Thank you.
Mr. Lane. I have Elijah Westbrook's, Judge.
Westbrooks.
Judge, we reached a plea agreement with Mr. Westbrook's. Mr. Westbrook has 2 cases before the court, 23 CF 1148.
If you got an extra copy of that, we're going to appreciate it. I can track it while you're going through it.
Yeah, just
Makes sense. Thank you.
he's also charged with 23 CF 2080. 1140s. I'm sorry, 11. Actually, in the box below, you'll see it says 1146. That should be 1148. Some typo on my part. Yeah.
You put 1146 on both of them. Is it 1146? 2 down here on row 46. Okay. There's no row 46, so row 48. Go ahead, Mr. Mendel.
He would be pleading as charged, no contest. He would receive 60 months Department of Corrections concurrent. In 1148, he has 222 days time served, and in 2080, he has 161 days time served. Mr. Velasco indicated that we would stipulate the score sheet. He scores, the score sheet that I was provided scores 133.4 total sentence points. So this would be below guidelines sentence.
Mr. Vaughn, what's an unenforced plea bargain, Robert?
Mr. Velasco indicated that he would provide a court with a score sheet later.
That's correct, Judge.
Very good. Just make sure that the defense approves it before it gets.
Absolutely.
We do agree that's that not.
Mr. Nail, can you read that number for me again?
The number on my score sheet is 133.4.
Thank you.
And I assume these are standard court costs and cost of prosecution. Madam Clerk, in 1148, what are the cost of prosecution and the court costs?
Cost of prosecution is included, so it would be $550.
Sorry?
$550 total.
So that includes the cost of prosecution?
Yes.
Okay. And then same with 2080?
Yes, sir.
What is the court cost?
$550.
$550. Okay. And normally we provide 180 days to pay these court fees so that he won't have to get his driver's license when he gets out. Say it's 180 days to pay. So when you get out, you can have 6 months to pay the court fee, so it won't knock your driver's license out.
Yes. And is putting as charged to each count in each case?
I'm sorry?
Putting as charged to each count and case?
Yes.
Yes. Okay, Mr. Westbrook, if you raise your right hand, sir. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
State, the state's agreement.
That's correct, Judge.
Okay, so Mr. Westbrook, you have heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement. Just want to make sure you signed it. There you go. There's your signature. I see you signed that. My first question, did you read this plea agreement closely?
Yes, sir.
And did you go over it in detail with your attorney to make sure you had all your legal questions answered?
Yes, sir.
Because you're waiving some valuable legal rights by entering. You've gone through this before. This has been drug out for a good little while. I'm sure you've had a number of conversations. I want to make sure you understand you're waiving the right to go to a trial, contest all this, have the state prove their case beyond every reasonable doubt. You're waiving those. Say, no, I want to file a resolution.
Yes, sir.
You believe this is in your best interest to do this?
Yes, sir.
And there is a factual basis, counsel, for this plea agreement?
Yes, sir.
And no DNA to exonerate?
No, sir.
And you do believe this is in your best interest to do this here today?
Yes, sir.
Okay. Very good. Based upon that testimony, then, the court will accept your plea agreement. And the court will sentence you as follows. This to count 1, 23 CF 1148. On the arson charge, the court will sentence the defendant to 60 months in the Department of Corrections. You will get credit for all time served, which is being stipulated to, in this case, 220 days.
222.
222 days. Did I say 220? 222, correct. The court costs of $515 in this. You have 180 days to pay those after you get released. As to the other count, 23 CF 2080, the 2 misdemeanor counts, which is counts 2 and 3, you'll get credit for time served. And that means those will, you'll not have to result, you don't have to do no probation, no further incarceration on that. As to count 1 of 2080, the court will also sentence you to 60 months, 60 months in the Department of Corrections. And those will run concurrent with the other charge, with 1146.
Yes,
It's a total of 60 months, which of course is 5 years. In 2080, you will also get credit for time served, and there's stipulated amount in that case, in that charge, of 161 days. You'll have, likewise, you'll have 180 days to pay your court costs after you get out.
Yes, sir.
One thing needs to be corrected, Judge.
Sure.
Under 2080, which says concurrent with 20, it should say 1148.
Okay, yep, you're right. Very good. So the two cases that I've announced are running together.
Yes, sir.
Okay. Now, even though you just agreed to this plea, you signed everything, you do have 30 days to appeal. Okay?
Yes, sir.
Okay. Mr. Neville, anything else?
No, you're not.
Thank you very much. You also going to give me a score sheet, right?
That's correct.
No downward departure.
Just your place there.
Or is it small? Okay.
That's correct.
That's why I unforced.
Don't press, just.
Very good. What about Jamarian Pride? Did we continue that one? I know we continued Keontae. Did we
The
continue?
state asked for continuance.
Okay. Continue to the next item?
Yes.
Okay. We'll continue to 410.
So 4AC out of custody, 410 Z in custody. Thank you, Judge.
Thank you, Mr. Neville. Have a good day, sir. Okay. Mr. Harper, let's go ahead and let's take a short break and we'll stretch. And we'll come back in about 10 minutes.
All rise, please. Court is at recess.